most of you probably know that this moot court competition was the brainchild of our Columbia chapter. And they came to us with the idea, they worked out all the details of the problem that was going to be addressed, and figured out all the logistics of actually running the competition. And so I want to say, and I would like all of us to say thank you to Columbia for We are extremely honored to have named this competition in honor of Judge Constance Baker Motley. And her son Joel is here this evening. We are truly honored to have you with us. Thank you so much. In Judge Motley's career, many people have said that she broke barriers literally almost every single day. And Julian Bond, chairman of the NAACP National Board of Directors, said her legal brilliance illuminated many dark courtrooms where justice was denied and let its light shine in. And what I'd like to say is I hope that her passion and values are an inspiration to everybody who participates in this competition over the years. I think it's really tremendous for us to have started this competition, and particularly for it to be named in her honor. In just a few minutes, you are going to hear from our terrific finalists, Sonia Mays and Adam Little, who are from the University of Michigan Law School, and Suzanne Leah Bratton and Andrea Schmidt from the University of Washington School of Law. I actually was lucky enough to judge a semifinal round of the moot court competition, so I've seen these guys in action and can tell you that you are in for a treat. It's really, the level of competition has been absolutely spectacular. Our Supreme Court this evening is Judge Slobiter from the U.S. Court of Appeals for the Third Circuit, Judge McKee from the U.S. Court of Appeals for the Third Circuit, and Judge Blake from the U.S. District Court for the District of Maryland. Justices, we are honored to have you with us this evening. Before we move on to the competition, I want to ask Roger Wilkins, ACS board member, to come say a few words about Constance Baker Motley. Roger himself has broken a few barriers along the way as Assistant Attorney General under President Johnson, and a Pulitzer Prize-winning journalist for his role in helping to expose the Watergate scandal. And Roger, I believe, first came to know Judge Motley when he was working at the NAACP Legal Defense Fund in law school, and they became fast friends and compatriots over the years. And so he is going to help us inaugurate the competition and share some stories.
I was urged by this gentleman to stand here. It really is my great honor to represent my colleagues on the American Constitution Society Board in dedicating this competition and all future competitions that we sponsor in the name of Judge Constance Baker Motley. You could take Connie's career and just go down the jobs. She worked for Thurgood Marshall right out of law school. She argued 10 cases at the Supreme Court of the United States and won 9 of them. She worked on the Brown v. Board 1, Brown v. Board 2. She argued the Supreme Court case getting James Meredith into the University of Mississippi. In 1964, she became a New York State Senator, the first black woman to so serve. 65, she was elected president of the Borough of Manhattan, first black woman to so serve. In 66, she was appointed federal district judge, Southern District of New York, first black federal judge. And in 86, she became the chief judge of her court, and in, I think, 88, took senior status. Those are the cold, hard, astonishing facts of Connie Motley's professional life. Here's the Connie Motley I first met. It was before I went to law school. I was a sophomore, junior in college, and I was a member of the NAACP, president of NAACP at my university, and a member of the youth branch of my hometown, Grand Rapids, Michigan's NAACP. And one night we were at a meeting, and we had some of the adult people there, and some of the kids began telling stories about how their parents had problems with finding decent housing. And one of the adult women, a wealthy woman named Hillary Bissell, was very confident. She was very idealistic, and she was very energetic. And she heard these stories. She jumped up and said, "Thurgood should know about this immediately." And she went to the telephone about 10 o'clock at night and called Thurgood Marshall. I thought she was insane, and I thought he might cuss her out. She wasn't insane. He didn't cuss her out. As a matter of fact, probably to get her off the phone, he said he'd come out and look at the problem. Instead, in a week or so, we learned that Marshall wasn't coming, but he was sending a lawyer, a woman lawyer, a black woman lawyer. I want to tell you, they had never heard of such a creature in Grand Rapids, Michigan in 1951 or 52. There were very few women lawyers of any kind, but surely few black ones. And so the people in Grand Rapids started mumbling and groaning about how they had been dismissed by Thurgood Marshall. But there came the day, and Connie walked into this room, all these people who thought she was a symbol of how Marshall had dismissed them, but they immediately began to change their minds because Connie had such gravitas. Matter of fact, having known her for quite a while, I think Connie was born with gravitas. And she walked into the room and she made a statement about the law, and then she said, "Now, I want you to tell me, what are the facts?" Well, the people didn't have any facts. What they had was anecdotes, and they had passion. And they had a couple of lawyers there who were no better with the facts. And so finally, Connie told them they had to get the facts. So, or she could not fashion a lawsuit. And then she looked at them and said, "Hurt feelings do not constitute a cause of action." Well, I hadn't been to law school yet. I didn't know quite what a cause of action was, but I knew that somehow Connie had laid some heavy wood on those people. Turned out that they did get some facts. Connie came back. She threatened to sue, and instead she was able to work out a very, very effective settlement. My second story about Judge Motley comes in the summer of 1955. Legal Defense Fund had just, in 54, won the main case. In 55, they did Brown 2, and I was a summer intern at the Legal Defense Fund that summer. I had known the man I ultimately called Judge in the end of his life. He wasn't a judge this time, but I had known Judge Marshall from the time I was a child. But he was, without a doubt, one of the most famous lawyers in the country in 55, and surely the most famous black lawyer. I went into his office the first day, and he said, "I want you to do some work for me on the 14th Amendment." And I looked at him. I must have had the most incredulous look in the world. What could I tell this man about the 14th Amendment that he hadn't known for 15 years? He said, "You know, I've been doing all this equal protection stuff, but I'm a little rusty on the due process clause. Do me a memo on the due process clause of the 14th Amendment." I have only felt that feeling one other time in my life. And that was when, in 1966, President Johnson called me and said, "Roger, there's a riot in Chicago, and I want you to get on a plane right now and go out and do something about it." In both instances, I wanted to tell these great men, "Is you a fool?" But I went and I did this memo, and I gave it to Marshall, and I hoped he would lose it, but he didn't lose it. And one day, I was in the library, little library at LDF at that time, and it was a number of the regular staff lawyers were in there too, kind of more people than I would have expected, including Connie. And all of a sudden, Marshall appears at the door, and he's ostentatiously reading something. He's just leaning at the, and he keeps turning the pages, and to my horror, I realize what he's reading is my memorandum. And I just sat there with sweat pouring down my back. And he got to the end, and I thought, oh, God. And he looked at everybody and said, "Hey, y'all, this boy ain't as stupid as he looks." So everybody laughed. They thought it was funny, but they were all looking at me when they were laughing. And so it wasn't so much fun for me, and I kind of walked out of the room really terribly unstrung. And Connie came over to me, and she put her arm around my shoulder, and in that deep, reassuring voice of hers, she said, "The memo was just fine, and he likes you a lot." So, in addition to everything that her biography says, Judge Constance Baker Motley was one hell of a lawyer. She was a great American citizen, and she was a very nice human being.
Joel Motley has agreed to say a few words, which we are honored by.
Thank you all. Thank you, Roger Wilkins, for that lovely set of stories that really brought my mother back to life, I think, better than I could do for you right now. But I'll just say one or two things about the event this evening. I first went to moot courts in Washington, D.C. when I was about 10, in the early 60s, at Howard University, where every time there was a major civil rights argument in the Supreme Court, the professors at Howard would organize with the Legal Defense Fund a moot court, just like we're having tonight, and try to poke holes in what the lawyers were preparing. And so this is a tradition that is integral to success in the law and success at the appellate courts. There have been a lot of great things said about my mother that I heard for years and years, and I think the one that struck me the most with the greatest surprise and, in a sense, the greatest sense of appreciation of some of her talent was when I read in William Douglas's autobiography, in his chapter on litigators who appeared before the Supreme Court in his 40 years there, that my mother was one of the 10 most effective litigators that he saw in that time. And I thought, my goodness, that is really something that, as my mother used to say, they can't take away from you. So I wish you both a lot of luck, and thank the Society, which is doing something that my mother believed was essential, and that is to establish within law schools institutes and groups like the Society, which would incubate the ideas that would eventually prevail for the causes that she believed in and fought for. So congratulations to all of you, and have a good round.
We are convened today to hear Maryland State Board of Elections versus Coolidge. We'll hear from the petitioners first.
Madam Chief Justice, and may it please the Court. My name is Adam Lytle, and I am here on behalf of petitioners to show why the Voting Rights Act does not apply to Maryland's race-neutral felon disenfranchisement law. My co-counsel, Ms. Sonia Mays, will further argue that Maryland's election law, Section 3102, does not violate the Eighth Amendment. I would like to reserve 15 minutes for myself, 13 minutes for my co-counsel, and 2 minutes for rebuttal.
That's granted.
Your Honors, there are 3 independent reasons why the VRA does not reach felon disenfranchisement. First and most important, doing so would raise a constitutional question by expanding the scope of Congress's remedial authority under the 14th.
How would it expand the scope? How would this statute expand the scope?
Your Honor, it's not the statute in and of itself. It's the application of it to felon disenfranchisement.
Well, isn't it every statute that we only look at in terms of how it applies? I mean, you're saying it's not the statute, but the application of the statute.
Yes, Your Honor.
To me, that's the same thing as saying it's the statute.
Yes, Your Honor, which is exactly why Judge Kaczynski in his dissent to Farrakhan v. Washington argued that if we did expand Section 2 of the VRA to felon disenfranchisement, it would render the whole section unconstitutional.
Why don't you start by telling us what is the procedural posture of the case that's before us?
Yes, Your Honor. Procedurally, this case was decided by the district court for petitioners in that the VRA did not extend to felon disenfranchisement. The Fourth Circuit overruled.
So you agree with the district court?
Yes, Your Honor. Now,
and you think that this case can be decided on the papers, or does there need to be evidence?
Your Honors, I construe your question to mean legally on the papers.
Well, however, you want us to do what the district court did, which is throw out the case.
Yes, Your Honor.
Okay, and you think that's the right answer?
That's correct, Your Honor.
Even just on the papers, without any evidence whatsoever of the effect of the
yes, regardless of what facts respondents could show, there is no way that the VRA could constitutionally
now
reach.
go back to Judge McKee's question.
Yes, Your Honor.
It's still out there.
So, obviously, Congress can go beyond the scope of the 14th and 15th Amendments, the exact text. City of Rome held that in their enforcement authority. However, there is a very specific way in which they have to do that. In 1997, the court ruled in City of Bernie that there must be a proportionality and congruence between, quote, the injury to be prevented or remedied and the means adopted to that end.
What is the injury here? If it applies, if the Act applies, what is the injury it applies to?
The injury would be unconstitutional effects of felon disenfranchisement.
Based upon what?
Based upon either intentional discrimination. There could be 2 ways. There could either be intentional discrimination.
Is there any question about intentional discrimination in this case? What's intentionally discriminatory, the Voting Rights Act or the statute?
The statute would be. The point, Your Honor, is that that is the only way in which the Supreme Court has allowed a claim to go forward with felon disenfranchisement.
They haven't looked at a situation with a discriminatory impact, have they?
No, Your Honor. The Court has never ruled on Section 2 of the VRA in that respect.
If they could show that this statute in application has a discriminatory impact, that has the impact of disenfranchising blacks on account of race, why wouldn't that be an application of the Voters' Rights Act, the VRA?
Because, Your Honor, the court cannot do that. Congress has a burden under Section 5 of the 14th Amendment.
The court cannot do what?
The court cannot make that finding and enlarge
Which
Congress.
district court?
Any
This
court. It's the role of the branch of the legislature in this case. And Congress must have
Well,
made
how would the legislature make a finding? All I'm trying to get at is if they can show, by introducing sufficient, whatever it is, statistical evidence, whatever, that this statute in its application has a disproportionate impact upon blacks in the particular jurisdiction, and that because of that, blacks in the particular jurisdiction are disenfranchised on account of race, why wouldn't that fall squarely within the 15th Amendment's prohibition?
Because Congress never validated that power in the way that they have to. It's an unconstitutional use of the power because there was absolutely no finding.
Well, if it falls within the 15th Amendment, it wouldn't be an unconstitutional
But in
use
order
of
for
the power.
in order for it to fall within the 15th Amendment, there would have to be intentional discrimination.
If I understood your position to begin with, you don't think that Voting Rights Act Section 2 applies in the felon disenfranchisement system section at all, and I understand that to be that you're saying you're looking for a clear statement. And I guess I'd like to know a little bit more why you think we would even have to get to the clear statement rule. What is the ambiguity in the...
The clear statement is a separate and independent argument. However,
Yes.
that is another doctrine of constitutional avoidance, which petitioners argue you could decide on. Now, a clear statement is required because applying the VRA to felon disenfranchisement would upset the federal-state balance. Section 2...
Well, that would turn on your answer to my question, though, wouldn't it? Because if the 15th Amendment already does what your colleagues over there say it does in this context, it's not the statute that upsets the balance, to use your term. It's the 15th Amendment.
But specifically, felon disenfranchisement was reserved to the states in Section 2 of the 14th Amendment. This is a reservation which was not left to any other form of voting qualification.
The 15th Amendment simply said that a state would not lose its proportional representation because of certain things, rebellion or a crime. But it did not reserve to the states the right to disenfranchise beyond that, did it?
It's not an absolute right, Your Honor. That's correct. However, Justice Rehnquist in Richardson v. Ramirez held that we could not expect Section 1 to bar outright, and that was the equal protection claim, felon disenfranchisement, which was exempted from the less severe sanction of Section 2 of the 14th Amendment.
But the court in Hunter said that if there was intentional
Correct.
discrimination,
Correct, which is not
racial discrimination,
which is not alleged in this case, Your Honor. The point is that Section 2 of the 14th Amendment means that there's a...
But wasn't the Voting Rights Act enacted in order to take care of cases where you couldn't find intent, but you could find effect?
In order to enlarge sort of the effect of the 14th and 15th Amendments and enforce that. That's correct. However, there's a presumptive constitutionality.
So why can you throw it out on the basis of the complaint, which is why I started with the question of why can you throw it out on the basis of the complaint without having any evidence as to the effect?
Because effects can never be enough with regard to felon disenfranchisement. There is a presumptive constitutionality of felon disenfranchisement laws, which is why Congress put it in Section 2 of the 14th Amendment.
I'm not sure where you're getting this presumptive constitutionality from.
Well, Your Honor, the argument is an extension of again, Richardson v. Ramirez, which is the only case that held directly on this point. Hunter did not overrule Richardson. It only created a narrow window in which, first of all, intentional discrimination would have to be shown in the passage of the statute, and second of all, the statute would not have been passed if it were not for that intentional
discrimination. Well, how can we decide what the intent was without having more evidence on the record?
Well, Your Honor, there's absolutely no intent alleged, so you can dismiss the case on that. There's only an effects-based crime here. We're talking about statistics.
But that goes to my question. If the effect is to disenfranchise on the account of race, and that's what they're alleging, then why wouldn't that be enough to at least get them past the 12b6 motion?
Because the effects, that's still not an intent result.
But they're arguing that the statute is such and the Constitution is such that a specific intent is not necessary. We said a specific intent is necessary under the 14th Amendment due process clause.
Yes, Your Honor.
That's not what they're arguing, and that's not what is before us.
But allowing the VRA to reach that would redefine the 14th Amendment, which is not the role of Congress. because of Section 2 of the 14th Amendment. The only way the Supreme Court has held in which you can have a violation with felon disenfranchisement is when there's this intentional discrimination.
Because that was the only issue before the court. You answered my question earlier that we've never specifically looked at this issue. We have looked at a situation where intentional discrimination or discriminatory motive is alleged, not where disparate impact is alleged. So you're saying that a situation that alleges disparate impact is governed by a situation that is controlled by a specific intent, even though the 15th Amendment, according to them anyhow, would seem to sweep broader than the specific intent, as long as you can show the causal nexus.
Your Honor, the first part of your question, let me address first. Hunter v. Underwood did actually comment on effects, and it said that you would have to show intentional discrimination. So
because that was what was alleged in the Alabama statute. And it was pretty clear in Alabama that was the motivation.
But they did comment that this was a narrow window, and they laid out the specific situation in which you would have to have those alleged violations.
If we don't agree with you that the VRA is unconstitutional without, then what's your next best argument?
Just to clarify, we're not saying the VRA is unconstitutional only in regards to this application, a felon disenfranchisement. Otherwise, it's constitutional, as has been shown in South Carolina v. Katzenbach.
Well, that's what troubles me, because it seems like the 15th Amendment allows it to have this particular application.
But the 15th Amendment did not obviate the 14th Amendment. Section 2 of the 14th Amendment still stands. And most of the courts, when applying these rules, have looked to the enforcement authority of both amendments and conflated them. There's still this congruence and proportionality test of City of Bernie. Tennessee v. Lane used the same test. Further in Nevada v. Hibbs, you have got to show a specific record of constitutional violations to be remedied. And Congress has never mentioned this.
Please go back to my question.
Yes.
Suppose we don't accept your argument that you cannot apply the Voting Rights Act to felon disenfranchisement. What's your next best argument?
The next best argument is the clear statement rule, which I began in regards to Justice Blake's question. And Gregory v. Ashcroft required Congress to make, quote, unmistakably clear in the language of a statute that they want to upset the federal-state balance in applying the statute as such.
So that only applies, the rule of Gregory would only apply, depending on how you answer my initial question, and that is whether or not it's the statute that is upsetting the constitutional balance, or whether or not this is simply a manifestation of the constitutional balancing that we get out of the 15th and 14th Amendments.
Correct, Your Honor. And I still stand that Section 2 of the 14th Amendment creates an express permission which does not exist with the balance of any other voting qualification.
Could we get back to the statutory question for just a moment? We've gotten diverted back to the Constitution, but to get to the clear statement rule, doesn't there have to be an ambiguity in the statutory language?
That is what respondents argue. However,
isn't that what we've said?
Yes, Your Honor, in several cases. However, in a recent case, Specter v. Norwegian Cruise Line in 2005, the court ruled that a clear statement rules ensures that Congress does not, by broad or general language, legislate on a sensitive topic inadvertently or without due deliberation. The statute has to be so unambiguous that the clear statement is contained within the language of the statute. And with regard to felon disenfranchisement, because of partly Section 2 of the 14th Amendment, that does not exist.
You mean you think if the statute didn't, it's because it specifically does not mention felon disenfranchisement or disenfranchisement as in the statutory section itself, it cannot
well, or the Senate or House reports, some sort of congressional language that makes a clear statement.
So you're saying they would have had to go through and catalog every conceivable way that someone could effectuate discrimination on account of race in order to get around the rule of Gregory?
No, Your Honor. Only if the Constitution itself had made an exception for those specific voting qualifications. Furthermore, the court did, with the same sort of qualifications like literacy tests, which have been around for a long time. Keep in mind, felon disenfranchisement has been around for over 200 years, since before the founding of this nation. With such a large and obvious qualification, the court did go down the line and mention these in regard to the preclearance provisions or what have you. And for felon disenfranchisement, it's not mentioned except for in Section 4C in 1965, in which the Judiciary Committees of both the House and the Senate said that felon disenfranchisement was exempted.
Now, if you agree that the Maryland statute has a disparate impact on African Americans, which you haven't said one way or the other, because you don't want to get to it, but
we'd like that, Your Honor.
But the allegations, of course, are that it does have a disparate impact. If it did, wouldn't it on its face be a violation of Section 1 of the Voting Rights Act?
Section 1.
Yeah.
Your Honor, because that's not the question before the court, and we were...
Well, it's the question before you right now, and I think it's tied in. It is tied into the question that we did certify.
Your Honor, I believe that the disparate impact requires totality of circumstances, as this court has ruled in Thornburg v. Jingles,
Well,
so it's not just...
totality of circumstances, can you do anything on the basis of the complaint? Don't you have to have more evidence before a district court?
You would if the law would actually apply. However, it would be a waste of your time and whatever lawyers would argue in front of you again if, no matter what the facts were, the law could not reach it.
But we may not agree with you. My question has, you're taking the hypothetical that we will agree with you, but we may not agree with you.
And in that case, I would lose anyway, Your Honor. I would rather save the court's time, and this is the threshold issue that we have to determine.
Concern,
But
our concern is the law.
Your colleagues might feel that your argument is a waste of our time, but we want to work through it anyhow.
Your Honor, the point being that the court has held consistently in this area, and the lower court splits specifically, except for the Ninth Circuit, all support the idea that felon disenfranchisement is immune from such VRA challenges.
Why was Judge Barquette wrong in her dissent then? I mean, in the 11th Circuit case, her point was we're not saying that there cannot be felon disenfranchisement laws at all, that we're not suggesting that at all. But if that is applied in a way to have a racially discriminatory impact, then it certainly seems to come within the intent of Congress.
Your time is up, but you can answer that question.
Thank you, Your Honor.
You're not saved by the red sign.
In that situation, Judge Barquette is wrong for the exact same reasons why we are before the court today. The disparate impact would unfortunately never be enough for felon disenfranchisement because Congress simply does not have the power to reach it to the VRA.
Thank you.
Thank you, Your Honors.
We'll hear the respondents.
Good evening, Madam Chief Justice. May it please the court?
Not just me, there are two other people.
Yes.
Here too.
May it please the court. My name is Suzanne Leah Broughton, and my co-counsel, Andrea Schmidt, and I represent Mr. Jeffrey Coolidge, the respondent. Ms. Schmidt and I will each address the court for 15 minutes. Your Honors, we ask the court today to affirm the judgment of the Fourth Circuit Court of Appeals and remand this case back to the district court so that Mr. Coolidge may make his claims under the Voting Rights Act and the Eighth Amendment. And I will begin with addressing Mr. Coolidge's Voting Rights Act claim. Ms. Schmidt will address his Eighth Amendment concerns. I would like to address two main points. First, that Maryland's election law falls unambiguously within the plain meaning of the Voting Rights Act, and that the Voting Rights Act is constitutional legislation.
Saying it's unambiguous within the...
That is correct, Your Honor. It is...
It's unambiguous because it doesn't have in it what you wanted to say in order for you to win? Or why is it unambiguous?
It is unambiguous as Judge Barquette noted in her
dissent.
Opinion, in her dissent, yes. Citing this case in Connecticut National Bank v. Germain, that the first step in any statutory interpretation requires the court to apply the plain meaning of a statutory language unless it's ambiguous. So we should look at the text of the language.
We just put the rabbit in the hat. We look at the text of the rabbit unless it's ambiguous. And the question here is whether or not this is ambiguous.
Right. And we should first look at the text of the language. So the record
of the statute of the Maryland statute or the Voting Rights Act?
Both, and how they interact. So in this case, it's clear that it's unambiguous. The Voting Rights Act says that there can be no voting qualification which can be imposed that results in the denial of the right to vote on account of race. The important term here is voting qualification. If you look at Maryland's...
Isn't it true that the Senate rejected any suggestion that this would apply to felon disenfranchisement?
Only in regards to Section 4 of the Voting Rights Act. They made no comments regarding Section 2 of the Voting Rights Act.
But is there anything at all? Is there anything at all in the reports or the Senate history? Anything that would suggest that the Senate and House did have felon disenfranchisement in mind, particularly in light of a long history of felon disenfranchisement in our country?
No, and they didn't need to in that instance. What Congress, coming back to the ambiguity, and then I'll return to Congress's what Congress found. Looking at the plain text of a statute, you would find it's ambiguous as the text is applied. So Maryland's law states specifically that a person is not qualified to vote if they fall under the requisite provisions of the Voting Rights Act. So we have a voting.
Mr. Coolidge definitely fell within them.
He did, and so this is a voting qualification, unambiguously.
But
Voting
that doesn't
Rights Act
automatically
applies.
put it within the VRA, does it? Just because it's a voting qualification?
Under what the issue that this court is deciding essentially falls on that issue.
Well, there's a lot more to the Voting Rights Act than just whether or not a person is allowed to vote. Otherwise, a minor could sue under the Voting Rights Act. Somebody who's mentally incompetent could sue under the Voting Rights Act. Somebody who's not a resident of the jurisdiction in question could sue under the Voting Rights Act. There's more to the statute than you're giving us.
There is, in fact. The Voting Rights Act does not allow a voting qualification that results in the denial of the right to vote on account of race. Now, that on account of race is to be viewed under the totality of the circumstances, and that's what we are asking this court to remand back to the district court to decide. They specifically did not address this fact.
But even that's a causation issue. Even if you could win on causation and somehow show that this Maryland statute, even though it's only Baltimore County and the other hurdles you have to jump through, would qualify under the specific language here. Given what you were asked earlier about the history of felon disenfranchisement, Congress's reaction after Bolton was decided, it was clear that this is not the kind of issue that Congress was ignorant of. But they did not specifically include it in the statute. If anything, as was mentioned earlier, when it was mentioned in a way as to suggest that this statute was not intended to infringe upon the state's rights to disenfranchise based upon criminal history.
In Congress's discussion under Section 4, it makes sense that they would have not wanted to prohibit all voting or all felon disenfranchisement. And we see that.
Say that again. Would you explain what you just said?
I'll explain. It makes sense that under Section 4, they did not want to prohibit all all felon disenfranchisement laws. We see there is
any indication that Congress believed state convict disenfranchisement was a problem that needed a remedy?
There is no discussion within the Senate record. However,
don't you? I mean, it thought racial discrimination was a problem, but that's not the comparator. I mean, under City of Bourne versus Flores, don't you have to show that Congress was concerned about felon disenfranchisement? Not race alone.
In this instance, Congress did find a number of violations. The states
say that where
using voting qualifications. Before the Voting Rights Act was enacted, Congress had attempted to, and this is in the Senate record, Congress had attempted to address the varied ways that states used voting qualifications to deny the right to vote on account of race.
And that's why they passed the Voting Rights Act. But that has nothing to do with state convict disenfranchisement.
Well, would you take the position that it's not necessary to mention specifically felon disenfranchisement as long as they've made substantial findings about a history of voter discrimination?
Right. In this context, because
That's what we call a softball.
Yes.
It's about time.
Yes.
Isn't that different than the convict disenfranchisement? Sure. I mean, we all know that there was racial discrimination.
And Congress knew it. Congress knew it, and they could have easily put that in. And you'd think, in fact, that would be one of the things foremost in their concern, given the ways that the legislatures had come up, state legislatures, had come up with denying the blacks the right to vote. Congress knew that.
Say anything about it.
They didn't say anything in Section 2. They didn't want to.
Is there any section here? Is there any section where they did say anything about felony disenfranchisement legislation, given the history they were legislating against?
they mention it in Section 4, and they decided not to invalidate all felon disenfranchisement, but that does not mean...
You said they mentioned it in Section 4. Is it in the statute?
It's not in the statute. Right. And under Section 2, Congress specifically did not make a list of all of the possible voting qualifications that could fit under Section 2. They did say that they wanted Section 2 to have the broadest possible scope. This court in Chisholm v. Romer affirmed that the Voting Rights Act should be viewed in the broadest possible scope.
Well, what about Mr. Lytle's argument about city of born and the necessity for some kind of finding? And one would think that given the extent to which this is chiseled into the history of this country, this is an area where you would expect a finding on the part of Congress if they intended to go into that area and have this bill apply to that, wouldn't you?
And be a remedy for that under Flores.
Again, in City of Bernie v. Flores does require a history, that Congress had viewed a history. However, they did have a long history of the varied methods that states used in order to deny the right to vote on account of race. They found that every time that they prohibited a certain qualification, the states would use another one, and that was why they specifically did not include a list of all possible voting qualifications that could fit.
Anything about felon disenfranchisement. I mean, that's the only issue that's before us right now.
They
not
did
racial discrimination.
We are not. I should emphasize to the court that we are not asking the court to invalidate all felon disenfranchisement laws today. Only those that violate the Voting Rights Act, that result in discrimination based on race.
So what would you have to show in order to come within the Voting Rights Act?
Well, first, we have here a voting qualification, and that is the first step. And then the court would do a totality of the circumstances review, and that is what we are asking the district, for you to remand to the district court to do.
Are you simply concerned with the permanent disenfranchisement part of the Maryland statute, or would your argument apply equally to the temporary disenfranchisement?
My argument would apply the same to any voting qualification that serves to deny the right to vote on account of race. That includes a disenfranchisement scheme.
It doesn't say anything about race, does it? Where is the word race in the Maryland statute?
Oh, in the Maryland statute, there isn't. But that is not the crucial point that this court should be concerned with. Voting qualification is the point that
If you're right about any qualification that goes to a racial disenfranchisement would create a problem in your view under the Voters' Rights Act, then even those statutes which appear to pretty easily pass muster, and those are the ones where you're disenfranchised for the term of your incarceration, even those statutes under your approach to this statute would fall.
Those would
You'd have prisoners voting by absentee ballot.
That's right. What is your position on that?
Well, first, that this Mr. Coolidge is not asking this court to give him his right to vote while he is incarcerated, only after his imprisonment. However, I would argue that there would be other regulatory purposes for disenfranchising people while in prison, so there is a difference.
Okay, that's kind of the Eighth Amendment argument, though. Just in terms of how we look at this statute, if we look at it in terms of any disenfranchisement coming on account of race, giving you that you can show it statistically, then aren't you asking us to write an opinion that really upsets the balance here by saying that states you have to let your incarcerated felons vote by absentee ballot? That's where your argument gets us.
That is not what we are arguing today. This court can hold on a more limited and a more narrow holding that only post-incarceration,
But what would it look like? How would we logically get there, given how you want us to view the statute? How would we logically write something that narrow when your argument sweeps that broadly?
I don't know that I have a thorough answer for Your Honor right now on that issue, only to say that this is not an issue before the court, and the court may hold narrowly and not applying this, and that there may be other...
And you want us to write our own damn opinions, and you're not being paid to draft opinions for us. I can appreciate that.
You want us to uphold the Court of Appeals.
We do.
The Court of Appeals in this case said the extensive findings that Congress made regarding widespread and ingrained racial discrimination in voting suffice to motivate the full coverage of the Act without the necessity of findings specific to felon disenfranchisement. You think that's right?
I would submit that that is correct.
What kind of reasoning is that? Doesn't the Act itself require findings?
Findings as to...
Causation.
well.
Yes,
account-
as under the totality of the circumstances, the district court must make findings. Are you
I'm
sorry.
asking you whether the Court of Appeals statement can possibly be correct.
Perhaps I misunderstood. I thought it was findings in connection with the overall pattern of
Well, they
voting
say,
discrimination.
No, that they said necessity of findings specific to felon disenfranchisement without the necessity. Do you think that's right?
I would agree if my understanding is similar to the Justice, that they are referring to Congress's need to find under the Bernie line. The Congress need to find specific violations regarding felon disenfranchisement. However, again, Congress need not have made those specific findings. Now, Tennessee v. Lane gives us further instruction in reviewing what Congress did when they enacted the Voting Rights Act.
Well, that's a disability case.
It is a disability case. It's also an access to courts question. Now, what Tennessee v. Lane can show us is that when Congress is legislating to protect fundamental rights, especially when there's more than one right at issue, that it should be afforded broader discretion in enacting.
This right is a right which the Constitution, a document which is drafted to protect rights, specifically allows the abridgment of. It specifically says you can deny the right to vote based upon felony conviction or based upon.
It does.
criminal
However, it does not sanction denying the right to vote on account of race.
No, it doesn't.
Through that. And so,
But if you want us to look at it through the Lane eyes, doesn't the Fifth Amendment blow you out of the water on that? Because it's a different kind of prohibition here, a different kind of restriction.
Section 2 of the 14th Amendment, the other crimes provision that Your Honor refers to, is not an affirmative right of the states to disenfranchise across the board. It's simply a recognition that they may continue doing what they were doing before that section was enacted. That was a punishment provision. The purpose of it was to stop states from disenfranchising.
What do you mean on account of race, you said before? What is there in the Maryland statute that indicates it's on account of race?
The on account of race review is under the totality of the circumstances review, which we would ask you to remand to the district court to make that determination. It doesn't need to exist in the text of the Maryland statute, but showing the causation, the disparate impact, and the other accounts of racism that Mr. Coolidge has alleged.
So nobody could decide this on a 10B. Is that right? 10B5? You couldn't 10B6. You couldn't do it.
On a Rule 12, you couldn't decide the totality of the circumstances issue at this point. I see my time is up.
Just in time.
Yes. Thank you, Your Honor.
Thank you.
Thank you.
We'll hear rebuttal on this. Do we
Oh,
hear
no.
a rebuttal on this? Oh, petitioner 2. Okay. Sorry. We hear petitioner 2. Oh, I see. The names are there. I'm just not tall enough to see them. Okay. You didn't look.
Madam Chief Justice, and may it please the Court, I'm here to address Jeffrey Coolidge's Eighth Amendment challenge to Maryland's election law. Understanding that Eighth Amendment scrutiny only attaches to punishments, respondent erroneously characterizes Maryland's choice to regulate its voting pool as punitive.
Well, if it's not punitive, what is it? That it's tied in, this particular deprivation that Coolidge is bringing to us is tied into the seriousness of his crimes. It's escalating the same way a recidivist statute might, based upon his being a repeat offender and having committed a more serious crime after initially being punished for his drug distribution. Now, if that's not punishment, what is it? It looks like punishment to me.
Well, to begin with, this law is couched in Maryland's election statute. It sits alongside.
Is that determinative?
The placement of the law is not absolutely determinative, but it gives a very strong indication of the legislature's intention. And this law is couched inside of Maryland's greater election regulation statute. It sits alongside statutes that regulate minors' access to voting as well as the mentally incompetent access to voting. Even if Maryland's election law were to be interpreted as punishment, though, it still fails to meet the threshold set forth by this court for determining cruel and unusual punishment.
Can you tell me, and perhaps you've already just about conceded it, but if it's not punishment, why does it only apply to a second violent offense? I mean, if one were concerned from a civil point of view about regulating elections, one would think fraud, forgery, those kinds of offenses.
Maryland's this regulation is designed to protect the integrity of the voting process. And we all know that the right to vote.
How does it do that?
Well,
I mean, if somebody has finished parole or probation, whatever that person had, and is out having a job, how does this affect the integrity of the election?
The state very firmly believes that the right to vote is the essence of a democratic society. And
So we're going to take it away for life from someone who has committed a crime totally unrelated to the integrity of the voting process.
The Maryland legislature has made a very rational judgment that it's repeat felons
We have to decide that.
It's repeat felons who are more likely, repeat felons whose crimes have escalated to violence. It is this type of felon.
Really much of a felon. You know, 1 gram, it was 1 gram of cocaine and then 10 grams of cocaine.
He's a little bitty felon.
That's right. We deal in kilos.
The state actually characterizes his first crime as far more serious than that. It was a drug possession with the intent to distribute. It was 10 grams of cocaine.
Intent to distribute, but based on the amount of the drug. Yes.
Exactly, but it was a significant amount of cocaine, and this was followed by a subsequent.
What was the significant?
10 grams.
10 grams is a
yeah,
lot.
quite.
I don't know. I don't take it.
Well, 10 grams is. Neither do I, but that's definitely a multiple much greater than personal use. And so very clearly, his first crime very clearly was an intent-based drug crime, which we all know has very far-reaching consequences.
This is sounding more and more like punishment to me.
Even if it's
he had a
punishment.
serious crime, and therefore you're not going to let him vote.
And even if it's punishment, there's still a second threshold that has to be met by respondents, and that is that this particular punishment, felon disenfranchisement, is in and of itself cruel and unusual. And
back to your reason, though, because it's your rationale that I'm not sure I completely can accept. And the rationale was that it assists the integrity of the elections. Now, I can understand when somebody's in prison, you know, the word may go about, let's vote for X or vote for Y. Why does that apply to somebody who has finished giving society back what it exacted from him or her?
there are actually a number of reasons. Maryland.
One good one. Can you help me with that? I just need one good reason, because I can't find it.
Well, quite honestly, the best reason was given by this court in Trope v. Dulles, and it's that the loss of voting is a non-penal exercise of a state's rights to control the voting eligibility requirements. And in this particular instance in Maryland with Jeffrey Coolidge, as a repeat recidivist violent felon, Maryland has made the determination that that is just the type of behavior that is more likely to introduce intimidation and fraud into the vote.
But there's not very many states left that do this on a permanent basis. I mean, I would have to agree with you that the great majority of states have some felon disenfranchisement, but Maryland is a rapidly shrinking minority, isn't it, that does this permanently?
Actually, actually, 48 states practice some form of felon disenfranchisement.
But not permanent.
Permanently, it's practiced in a full quarter of the states. There are 13 states that practice a form of permanent felon disenfranchisement. And in addition to that, 2 states recently, Kansas and Utah, have strengthened their regimes.
But if the effect is disparate impact on a minority, in this case, African Americans, doesn't that make it different? I don't know what Kansas population is like, but we have some idea what Maryland's population is.
Potentially for the question of the 14th Amendment. However, under an 8th Amendment analysis, the threshold question is whether or not the punishment can be characterized as cruel and unusual. And this court has actually given us 3 clear statements outside of death penalty cases that give us guidance as to when a punishment does meet the threshold of being cruel and unusual. And this Maryland statute fails to reach the bar set in any of those cases. In Trope v. Dulles, the punishment in question was denaturalization. And the court characterized denaturalization as the complete destruction of a person's identity in society. Jeffrey Coolidge is free to walk around. He is free to make his own choices about what he eats, who he hangs out with, where he drives. This hardly represents the destruction of his identity in society.
Well, we've also talked about the importance of participation in a civic society and the importance of the right to vote and what it can mean to remove someone from their meaningful participation in a society, particularly when that society is a democracy. This is someone who's voted all their lives.
And with voting goes a certain level of social responsibility. And we're not talking about we're not talking about a voting restriction that's unilaterally applied to some group for a characteristic that they can't control. Jeffrey Coolidge made a conscious decision.
That's the problem, though. After he commits his second infamous offense, he is no longer free to control his status. He cannot vote, period.
Is there even a possibility of restoration of his civil rights under this?
Jeffrey Coolidge is free to petition the governor for clemency. So it's, again, it's not this absolute destruction of his identity in society, and it's not the same. It's not of the same absolute nature that the Solem court found objectionable when it struck down life imprisonment without the possibility of parole for writing a bad check. Jeffrey Coolidge's crimes are far more violent than the crimes that were dealt with in the Solem ruling. And in addition to that, one of the things that the court found highly objectionable in Solem was that a person who had committed several nonviolent crimes was given the second most severe punishment known to society. And in this instance, felon disenfranchisement is far from being the second most.
Don't we have to apply the Mendoza-Martinez factors to this before we agree with you?
Yes, and even applying those factors, applying those factors still gives us a punishment. Applying those factors gives us a really strong indication that what we're dealing with here is a regulatory statute that deals with voting eligibility. And
But I thought earlier you had conceded that it was punitive.
And I was going to return there again.
At least partially, isn't it at least partially punitive?
Even if it is partially punitive, in which case the Bell-Wolfish test would be the more applicable test. And
is it Bell-Wolfish or is it Austin? If it's only partly punitive, vis-a-vis if it is primarily punitive, which test should we look at?
The state strongly feels that under either test, this is a regulatory statute.
Why isn't it arbitrarily harsh?
The one case that this court, and the only time that this court has commented on a punishment being arbitrarily coarse, again outside of the death penalty context, is in Weems.
This certainly isn't that. Go ahead. Is which one?
Is in Weems. And to better answer that question, felon disenfranchisement is something that's expressly reserved to the states in the 14th Amendment. It was something that was contemplated it was not contemplated by the founders as something that would be a cruel and unusual punishment.
Well, does it matter? I mean, do we really have to go to what the founders thought? Weren't some things that the founders thought were okay are deemed now to be arbitrarily harsh?
One little
Good point. Quite honestly, our Constitution was designed by a group of very astute men, and
they came from and they met in Philadelphia.
Yeah, but it was
the question how astute they were.
It was designed for people of fundamentally differing views, and the enactment of the Eighth Amendment or the writing of the Eighth Amendment was purposely left broad to allow for changes in contemporary values.
Okay, so why? That's right. And so why haven't we evolved to the point where we think that all people should have the right to participate in the electoral process?
Especially since Armenia is the only other country that engages in this process. So isn't that some indicia of what an evolving standard would indicate?
If international opinions were anything more than informative in this court, possibly. However, international opinions have never been controlling. Even in Roper and Atkins, the court only looked to international opinions after it had made a finding that there was a consistency of change within the states. We don't have that here. We still have 48 states that are practicing this, 13 that are practicing the most harsh.
Well, 48 states, but not to the extent that Maryland
Not
does.
a permanent lifetime disability.
Exactly. Still, though, 13 states that are still practicing the most harsh form. No indication of states moving away from this practice. We have states that are moving.
Well, there's an indication that Maryland has moved away from this. Didn't Maryland make their statute a little bit more punitive, making it more difficult to get to that second hurdle?
Maryland did relax the threshold crimes, but it still practices permanent disenfranchisement. And so
and that's a problem before us.
Yes. And like the reasoning used in Atkins and Roper, without a finding of a consistent consistency of change away from the practice, it's difficult to step out to the international community. The legislature of each individual state is the most clearest and most reliable evidence of contemporary values. And when you have 13 states in the country who are still practicing permanent disenfranchisement, it's just very difficult to for that to reach the threshold required under this court's jurisprudence for striking it down under the evolving standards of decency doctrine. Additionally, this punishment also operates well within this court's jurisprudence on proportionality. Permanent loss of vote is reserved. It's not extended to all criminals in Maryland. It's only reserved for certain violent recidivist felons like Jeffrey Coolidge.
So, you know, when you look at the statutes, the offenses that Maryland lumps together under the definition of a violent offense and infamous offense, I'm not sure that proportionality is your strongest argument. Now, maybe you never even have to get there, but I'm not sure that you can't say that there's a problem with the way Maryland has this in terms of its proportionality.
If a person in Michigan can be convicted on a first-time offense of drug possession and sentenced to life imprisonment without the possibility of parole, then certainly someone who's committed a violent crime in Maryland, who is free to walk around, who is free to make day-to-day decisions like everyone else in society, that punishment can hardly be said to be disproportionate. And this court has given us a very clear standard as to, I see my time is up.
Finish your sentence. We want to hear you out.
This court has given us a very clear indication as to what the threshold is for proportionality, and this falls far short of that standard as given in Harmel. May I have a few moments to conclude,
No.
Chief Justice? Thank you for your time.
The red light's on. Thank you, Ms. Mays. Your respondent on this issue?
Good evening, Your Honors. May it please the Court, my name is Andrea Schmidt, and I also represent Jeffrey Coolidge, the respondent in this matter. The remaining issue in this case is whether the state of Maryland may, under the guise of regulating elections, punish Mr. Coolidge by depriving him of his right to vote and at the same time escape scrutiny under the Eighth Amendment. The Fourth Circuit Court of Appeals correctly held that it could not.
Isn't one of the last points that Ms. Mays mentioned was of course the Harmelin case? If mandatory life in prison without parole for 650 grams of cocaine is just not going to be prohibited by the Eighth Amendment, how can this be?
Your Honor, in Harmelin, the Harmelin court compared its findings or its facts to the case in Solem, in which the court did find that a man with 7 prior felony convictions could not be sentenced to life in prison. And the court there recognized that the crime in Harmelin was much more severe than the crimes in Solem. Now, the crimes in Mr. Coolidge's case are more similar to the crimes in Solem.
But I thought in Solem it was 7 nonviolent felonies, and here, I mean, even if, which I'm not saying I would agree with, but even if the drug distribution were nonviolent, the robbery of the store can hardly be characterized that way.
You're correct, Your Honor. The robbery was characterized as a violent crime. However, using the other factors that we use from the Solem case to measure the gravity of a person's offense, his crimes were actually relatively minor using those factors.
You're assuming this is a punishment. It's in the election law. It sets qualification. Why do we even apply the Eighth Amendment in this case?
Yes, Your Honor. According to the court in Bell v. Wolfish, in order to find that a restriction is not a punishment for the purposes of the Eighth Amendment, we must find that it is rationally assignable to a legitimate non-penal governmental interest.
Well, you clearly have that here. I mean, Bell v. Wolfish was pretrial detainees, and there was an issue about whether or not a pretrial detention rose to the level of punishment. But that kind of inquiry here seems to me, I don't know how you can possibly win. You'd concede the state has the right to maintain some requirement, some threshold requirement on who they're going to let vote as long as they don't do it in a discriminatory manner.
You're correct, Your Honor, but if
What's wrong with them saying that if you've committed certain criminal offenses, we're not going to let you in the voting booth?
Your Honor, if saying that certain criminal offenses are related directly to the commission of election crimes is not
No, they're not
logical,
saying that. They're simply saying that it's a way of regulating the election process, not necessarily because they're assuming that somebody who knows how to smoke dope is going to also engage in election fraud. They're not making that argument. They're simply saying that this is not the class of person. I assume this is what they're saying. They can make the argument better than me. This is not the class of person that we want to subject to the processes of voting. We want to guard our organs of voting against these persons being involved in the process. And what is wrong with that?
That sort of justification simply fails to meet the Bell test. It isn't rationally assignable to the purpose that they assign it to. Now,
But who would you rather have voting for President of the United States? Somebody with your client's record or somebody with no record of criminal offenses whatsoever?
Your Honor,
Knowing nothing else about them, who would you rather have voting?
Your Honor, that question would suggest that it is permissible to fence out people who we think might vote for the
No,
wrong
I'm not getting into the Roper-Romer issue. Just answer the question, and then we can get into the fencing out of unpopular folks if you want. But who would you rather have voting?
Your Honor, I would like both of those people to vote.
Very good.
I don't make this
Didn't answer the question, but it was a very artful dodge.
Yeah, I would have to interview that felon. I might have more in common with that person than I would with the other.
I'm not sure you want to tell us that. But go back to the question of the fact that it's a qualification under Maryland law.
Yes, Your Honor.
And you keep suggesting, well, saying that it's a punishment. Maryland hasn't put it in its penal code.
That's correct, Your Honor. But in the case in Bell, the court found specifically that a legislative classification of a punishment does not automatically make it a regulation. It has to pass the test in that it has to be rationally assignable.
But I find Bell singularly unhelpful.
So it doesn't matter.
Justice McKee gave you a rational reason. And
Right.
Ms. Mays gave a rational
The
explanation.
The text of the provision indicates that it is not rationally assignable to the prevention of election crime. Now, because it strips the right to vote from people who commit only subsequent violent felonies. Now, it doesn't take the right to vote away from people who commit election crime.
Well, can they have a good policy or a legitimate policy that maybe is not very well thought out and not very carefully articulated? Let's say it's a dumb law. But does that necessarily mean that it's not a regulation? It's just not a really wise regulation. It's a regulation driven by, let's assume, stereotypes and misconceptions, maybe even the kind of misconception you talked about earlier with fencing out certain classes of persons from the electoral process. But does that push it over from being a regulation into a penalty?
In this court in Austin versus the United States found that when a restriction serves at least in part to punish, that it's a punishment for the purpose.
Didn't that do with fines?
Excuse me?
Didn't that deal with fines, Austin?
It dealt with the exception.
And isn't this very, very different? We have a situation where we have pretrial detention on the one hand, fines on the other. Seems to me that this is just a very different kind of regulation. Even assuming that you may be right that it's a foolish regulation, if it is a regulation, and if it's a regulation going to the electoral process based upon whatever the Maryland legislature had in mind when they enacted it, that doesn't get it into the kind of realm that we had in Bell, where you're trying to figure out the length and conditions of pretrial confinement and whether or not that's an Eighth Amendment issue or a 14th Amendment issue. It's a very different kind of focus, isn't it?
The focus on the Eighth Amendment versus the 14th Amendment?
I'm saying the kind of deprivation that you have here, whether or not it can be viewed as a penalty or a regulation, is very different because it doesn't involve some of the deprivation inherent in either fines under Austin or pretrial detention under Bell. On its face, one way, I think the ordinary person would assume that the state can regulate who votes, and they would be expected to regulate who votes. You're saying they haven't done it very artfully or very wisely, but that does not necessarily mean it is a punishment. Maybe it's just a foolish regulation.
Your Honor, not only has the state not done it artfully, but they've done it illogically. And
Why?
in that
It's
case,
not a complete exclusion from society. It's a very small part of what this person's daily conduct involves.
Your Honor, that comment goes directly to the proportionality analysis, and I disagree. Losing the right to vote for life
You
is
disagree that it's not a complete. What is it that you disagree with?
I disagree with the assertion that losing the right to vote is not a big deal. I'll begin by...
Well, after all, look how many people don't vote, even if they have the right to vote.
Very correct, but Mr. Coolidge did vote. And now we are proposing to deprive him of his right to vote for life. The right to vote is a fundamental right under the equal protection jurisprudence of this court. In addition to that, he will be deprived of this right to vote 40 years after his last conviction, many years after he gets out of prison for the last time. Now,
Doesn't he have the opportunity to apply for clemency or pardon or have his civil rights restored?
there's a potential that he could apply for a gubernatorial pardon. However, this court in Solem held that executive clemency and the possibility for actual relief from a sentence are two vastly different things, and that there's also a very informative Minnesota Law Review article that tells us that pardons are ineffectual relief from this sort.
I could be wrong, but I thought we were not supposed to rely upon law review articles.
We weren't supposed to rely on
Law review articles.
law review.
Oh, no, that's sad.
There are some statistics.
I don't know.
Not after October 2nd.
I may have been less meeting than my colleagues.
There are statistics in that law review article which indicate that gubernatorial pardons are extremely rare and extremely ineffective. So all of the discussion of this provision considers this provision to be permanent.
All right. Let me ask about the one other that was certainly we heard quite a bit about from the other side. How can you say, shifting gears a little bit, with 13 states that still believe in permanent disenfranchisement, how can you say this is cruel and unusual? Or?
Your Honor, there are two lines of jurisprudence in Eighth Amendment analysis. One of them is that when a punishment violates current standards of decency, then we should disallow it across the board. That's what happened in Roper, in a death penalty case. Now, we don't. Excuse me?
Do you claim this does that?
No, we certainly don't. We only claim today that Mr. Coolidge has stated a valid claim that lifetime disenfranchisement is grossly disproportionate to his punishment. So we're asking this court to let him make that claim, to build the record before the district court.
But you still have to get to the first part of that hurdle to make that claim, though, don't you? You still have to show that this is, in fact, punitive as opposed to a regulation. It could be a regulation which is so broad and so oppressive and so onerous that it has the result that you're talking about, but it is still a regulation, unless you're arguing that you can take a regulation intended only as a regulation and apply it in such a way that it becomes a punishment. But I don't think you're arguing that. I didn't think of that as it is now, but I don't think you're arguing that, are you? Okay.
I can address Your Honor's concerns by giving a couple of more examples of why the legislative history shows that this provision is intended to be punitive. One of them is that in 2002, the state manifested what the Maryland Attorney General called a liberalization of the state's attitude toward the disenfranchisement of felons. Now, the Maryland Assembly changed the provision. It changed the provision from disenfranchising anyone who had committed an infamous crime and a subsequent infamous crime to only disenfranchising permanently those people who had committed an infamous crime and subsequently a violent felony. Now, the presumption would be that the state made this change because it wished only to punish the most severe of offenders for the most severe crimes, not because it was attempting to regulate elections better than it had regulated them before.
Isn't that rational? Based on what you just said, isn't Maryland, assuming that was the intent of the state, wasn't that a rational intent? And should we strike it then as arbitrary?
It may have been a rational punishment, but it wasn't rationally assignable to a non-penal purpose, which is the key in getting to the fact that it's a punishment. Now,
can you ever have, I want you to finish that question because that's a very helpful answer and helpful question, but can you ever have a rational punishment which is so excessive that it violates the Eighth Amendment? If conceding that that may be a rational punishment, does that then take you away from your Eighth Amendment claim? Does that undermine your Eighth Amendment claim?
Absolutely not, Your Honor. You can have a rational punishment which, as applied to a particular person with a particular set of crimes, would be grossly disproportionate to those crimes.
You've said you think that the permanent disenfranchisement is grossly disproportionate as applied to your client in light of his record.
Yes.
Could you give me an idea of a criminal record that you think would be worthy, where it would not be disproportionate to impose this kind of penalty?
I could give many examples. I'm guessing at how the court would treat them. But I would say that a person who had committed murder, a person who had committed rape, a person who had committed a crime in which violence was actually employed, for example, would be a closer.
Well, you're asking us to second guess that which the Maryland statute or Attorney General opinion says is violent? I mean, we don't have that to play that role. You're saying some violent crimes could be punished by permanent disenfranchisement, but not others.
Why are you saying that? They can be punished by permanent lifetime disenfranchisement? Is that what you're saying?
I'm saying certain violent crimes might be. I don't purport to establish.
Well, how do you make that distinction? How do you say that a rape is that much worse than a robbery?
Your Honor.
The rape has nothing whatsoever, no connection to disenfranchisement.
No, it doesn't, Your Honor. However, in order for us to do the necessary proportionality analysis, we have to look at the Solem factors, which the court established in order for us to measure the relative gravity of a person's crime.
You're saying
now,
if you ramp up the seriousness of the offense enough, then you're saying if you ramp up the seriousness of the offense enough, you could then have permanent disenfranchisement that wouldn't be excessive given the underlying crime, but your client's crime is not in that category. It's not ramped up high enough.
Yes, Your Honor. That's exactly what we are.
You were saying before that a crime that was related to elections would be could be an appropriate crime that was punished by permanent disenfranchisement.
In that case,
and that's not the position you've just taken. You've just taken the position that crimes you don't like, that you think are really serious, serious crimes could be, but they're not. Well, I'm about to finish the question. And then you can finish the answer.
I would love to answer, Your Honor. Those two statements are not contradictory. In the original instance, we were looking at whether something was a punishment or a regulation. Now, the state could regulate people who have committed election crime legitimately. That would be a non-penal exercise of the state's power. But when they are not regulating, when they're punishing, their punishment must be proportionate to the crime.
Thank you very much.
Thank you.
Thank you.
We will now hear the rebuttal. Are you doing the rebuttal for both issues?
Yes, Your Honor, although I'm actually only addressing one. This will be quite brief. Your Honors, I just want to respond to the point the respondent makes regarding Tennessee v. Lane, that since this is a fundamental right, for some reason the rights deserve, the Congress must go through a less onerous burden in their remedial authority steps under the City of Bernie cases. However, even in Tennessee v. Lane, on page 527, the court noticed that 527 of the opinion on Tennessee v. Lane, the court noted.
Okay, in what? Is there a U.S.
I'm not sure the exact reporter, Your Honor. However, the court noted, nonetheless, at the location that Congress showed 76% of public services and programs were inaccessible to and unusable by persons with disabilities. They were extremely specific in the record of unconstitutional behavior by the states, and there's nothing
in this case to put any evidence in because the district court threw it out completely.
But at the end of the day, we're not talking about the courts. We're talking about the burden on Congress, and Congress made that finding, and Congress must make.
But you're back to saying. No, go ahead.
In those cases, you had laws which swept very, very broadly across all kinds of behaviors and hit people in all different kinds of endeavors. That's not what we have here. We have a law which is very, very narrowly focused just to voting rights. That's it. And then it has to be on account of race. So why would Congress have to make the same kind of finding to sustain this kind of legislation that it had to sustain RFRA?
Conversely, Your Honor, it's not necessarily as narrowly tailored because it will apply to 48 states, as respondent admits with regard to felon disenfranchisement. It's not necessarily just the area of federal elections, it's local elections and state. And I see my time is up, but for these reasons, it's imperative that you reverse the decision of the Fourth Circuit.
Thank you.
The court will take the case under advisement.
All rise.
Yeah. I have some.
It is such a pleasure to see you all here tonight. I'm Mary Kelly Persine, former chapter president of Columbia ACS and one of the founders of the ACS Constance Baker Motley Moot Court in Constitutional Law. I'd like to take a moment to introduce my co-founders and ask them to stand. They are Keith Bradley, academic director, but I think Keith is actually with the judges. Oh, wait, no, there's Keith. Keith, stand up. Amos Blackman, Communications Director. Zara Egal, Logistics Director. And Jenny Bell, our Finance Director, who couldn't be here tonight. We started developing the we should give her a round of applause because she spent hundreds of hours. Lots of spreadsheets. We started developing the competition in the spring of 2005, envisioning a national moot court that could welcome competitors from every ACS law school chapter across the country. ACS National shared that goal and committed significant resources to working with us to make it happen. As we reached out to our fellow ACS members, we found great enthusiasm for this program. With the strong encouragement and assistance of the national office, we continue to grow our vision of the competition. In the end, 54 students from 17 schools in 16 states participated in the March competition, which was held at Columbia Law School, and over 150 lawyers and judges scored briefs and judged oral arguments. In all, more than 300 people were involved in the first annual competition, whether as judges, competitors, interested students, or volunteers. When it came time to name the competition, ACS sought a great American who would represent compassion, humanity, vision, and a fierce hunger for justice. Judge Constance Baker Motley, a legendary advocate with the NAACP Legal Defense and Educational Fund and the first African-American woman appointed to the federal judiciary, was just such an American. Her name will remind us always that the search for truth and the struggle for justice lie at the very heart of advocacy. We owe our thanks as well to Joel Motley III for his support of the moot court competition. ACS National continues to demonstrate its commitment to the educational and leadership development of law students by working to regionalize the competition, thus enabling more chapters and more students to take part. In the future, there will be multiple regional competitions that will serve to qualify a select few teams to a national competition here at the ACS Convention in Washington. It gives me great pleasure to announce that the 2007 Motley Moot Court regional competitions will take place at the University of Chicago and the University of California, Los Angeles. The 2007 competition directors will both be here this weekend, and one has joined us tonight. They are Daniel Ingber of the University of Chicago. Please stand, Daniel. And I have to say, I'm really happy to say that the second is Ryan Dunn of UCLA, my alma mater. So we'll applaud for him, though he's not here. We look forward to seeing the competition grow by leaps and bounds in the years to come. And we encourage all of you to consider participating as competitors, brief scorers, or judges. This is something you can do as students, but also after you leave law school as a way to remain one of the many ways in which you can remain involved with the American Constitution Society. Congratulations to our accomplished and talented finalists once again. And good luck to Daniel, Ryan, and their teams at UChicago and UCLA. Thank you so much for attending tonight's final round. We invite you to stay and relax for a moment while we await the final decision, which will be coming momentarily, and then to join us at the opening reception across the courtyard in the Sports and Fitness Building. Thank you.
Where are our lawyers? They disappeared.
Smart move. They're not getting billed, not getting paid now. They're out of here. Can't bill that time.
Before we do anything else, I want to second what was said before, to thank Columbia, and in particular Mr. Bradley, who was the person, I gather, who wrote the bench memorandum that we have. Is just one. Where are you?
Right there.
You're right there. And I'm sure he's very modest. I said to him, that's really great, and he said, well, it wasn't only me. I was part of a team. But I'm
So
sure
the whole
that
team.
It was in large part your instigation, and it's very impressive, and I think we will owe you. You and your team. I've been on the Court of Appeals for just about 27 years now. It's a long time. You should all say, she doesn't look it.
I'm not touching that.
What did you just say?
I'm not, nothing. I'm not saying anything. I'm very attentive. I'm listening.
Better not. We're on the same court. And I have precedence over him. And so I've heard a lot of oral arguments. And it's very hard for me to think of oral arguments, many, very few, that were as good as the ones that we heard from these four young people. They just did a fantastic job. Those of you who don't participate in moot court may not appreciate how much time it took. I mean, I was wiped out in my first moot court at law school. So I think I can do it now, but I'm not sure much better. These four young people, they knew the cases, they knew the problem, they knew the issues, they anticipated. So they should be finalists, I can tell you that. I'm not going to hold you all in suspense, but it was very hard. It was very hard for us to, we evaluated each person, and we have to do it by team. So the end result is that by a narrow margin, we give this to the respondents, which is Leah, Creighton, and Ms. Schmidt. Ms. Mays and Mr. Little, you were great too. I don't think our rules allow me to add. Can the other people up here comment? Okay. Go ahead, Catherine.
Sure. I'll just say that although I've been primarily on a district court, occasionally sitting with the Fourth Circuit, and it was very interesting in being in the Fourth Circuit to read this as a Fourth Circuit opinion, I would just join the wonderful quality of all four of you. It was just amazing. I obviously do hear oral argument on motions and things at the district court level, and you were very well prepared, very, despite being, I would say, peppered with difficult questions. You were calm, you were composed, and you gave us good answers, and I really appreciate it. You obviously worked very hard, so thanks to all four of you.
Yeah, it really wasn't any different than we would conduct ourselves at oral argument. We didn't ramp it up or go out of our way to give anybody a hard time because of the exercise. It was really the way that we conduct ourselves at oral argument. I couldn't help.
We sit together, and he always takes the longest questions.
Probably true. But the whole time I could not help but think how proud Judge Motley would be of this. I did not know her as well as I would have liked to have known her, but to the extent that I did know her, I know she would just be so proud of the effort, the quality of you young folks, the problem, and how the problem kind of encapsulates one of the things that is really needs to be looked at. I wouldn't say it was right or wrong, but one of the things that needs to be looked at in this society, which is creating a problem, which is a real problem, and someone needs to take a long, hard look at to see whether or not it is right or wrong. And it's just, I cannot imagine a better exercise in her memory, and I'm really proud and flattered to have been a part of it, and I thank you for that honor.
I should tell you that Judge McKee and I agreed that we don't know how we would decide the issue if and when it comes before the Third Circuit. It isn't there, and he thinks it's coming, and I think the Supreme Court will get it, I hope so, before we do. But the number of this issue is at the fore, not the cruel and unusual, not the Eighth Amendment issue, but the Voting Rights Act issue is a serious and very difficult issue. I spent a lot more time on this than I had anticipated having to spend in order to be able to ask intelligent questions. I mean, in moot court, I don't want to do a lot of moot courts because they're very time-consuming. We occasionally have cases that take us a lot of time. We have a death case coming up at the end of the month, and that's obviously going to take a lot of time. But this was hard, but it was worthwhile because it made, at least me, and I think Ted, and I don't know about how, made us look at an issue that we haven't had as a court, but that we should think about. And I'm sure that everybody here thinks about important issues because that's why you're part of an ACS contingent. So we thank ACS also for giving us this opportunity to study this issue. So thank you all. And we'll talk to you either now or for you or at the reception, whatever you'd like. Okay? Thank you all. Are these